Okay. Good morning, everyone. Welcome to this Planning, Taxi, Licensing and Rights of Way Committee meeting. My name is Councillor Carl Lewis and I have the pleasure of chairing this meeting today. First item on the agenda is apologies. Over to you, Carol, for apologies. Do a roll call as well, please.
Thank you, Chair. As you say, I'll do a roll call as well. So Councillor Carl Lewis.
Present.
Councillor Gareth D. Jones. Councillor Tom Colbert.
Present.
Councillor Angela Davis has given apologies. Councillor Deb Edwards. That's present. Councillor Les George. Councillor Hylwyn Hume.
Present.
Councillor Peter James.
Present.
Councillor Adrian Jones has sent apologies. Councillor Gareth E. Jones.
Present.
Councillor Karina Kenyon-Wade. Councillor Ian McIntosh.
Present.
Councillor Jeff Morgan. Councillor Gareth Pugh.
Councillor Gareth Pugh did say that he might have difficulty joining this morning, so.
Okay, I'll take that as apologies. Councillor Edwin Roderick. Councillor Gwynfor Thomas.
Good morning.
Councillor Elwyn Vaughan.
And
And we've also had apologies from councillors Jonathan Wilkinson and Hugh Williams.
Thank you very much, Carol. On to the second item on the agenda, which is to authorise me to sign the records of the meeting that transpired on the 7th of July 2022. I'll go through them. They're pages 5, 6, 7 and 8. Do I have someone to propose and second them, please? Thank you, Councillor Hallwyn. Do I have a seconder, please? Councillor Gwynfor, I believe. Thank you very much. On to item 3, which is on the agenda. A, to receive declarations of interest from members relating to items to be considered on the agenda. No. B, to receive members' requests that a record be made of the membership of town and community councils where discussion has taken place for matters for the consideration of this committee. Yep.
Hello, Chair. I'm not sure. I know there's something in Brontlis, which is in my ward. Am I supposed to make that known?
That will be later, Councillor
Okay.
Todd.
Okay.
Yeah.
Thank you, Chair.
Thank you. C, to receive declarations from members of the committee that they'll be acting as a local representative in the respect of an individual application being considered by the committee. I don't believe there is anyone. D, to note details of the members of the county council who are not members of the committee but will be acting as a local representative in respect of an individual application being considered by the committee. No. Okay. On to the planning applications. 4.1 updates. Has everyone read the update that came in yesterday? And has everyone had time in the chamber to read the update if they got it in the hard copy? If anyone hasn't, please raise your hand and I'll allow that time for you to read that. If you've read the paper, that's the update. Brilliant. Okay, on to 4.1, which is application 22/1288/DEM, Chris Audi, New Road, Newtown. Taking us through this application is Rhian Griffiths. Over to you, Rhian.
Okay, thank you, Chair, and good morning, members. The following presentation is in relation to a notification regarding the demolition of Croesaudi, made under Schedule 2, Part 31 of the Town and Country Planning General Permitted Development Order 1995. This is an aerial view map which shows the site as indicated. The site is within the settlement boundary of Newtown and fronts onto New Road. This is a closer view of the site from an aerial perspective. For context, Ladywell House, if you can see my mouse, is just to the north, and Newtown train station is to the located to the east. The proposal relates to the demolition of all buildings, outbuildings, boundary fences and gates, and the removal of all vegetation within the red line shown on this plan. Given that the site is not within a conservation area and does not have any tree preservation orders in place, no consent nor notification is needed in relation to the removal of vegetation. Class B of Part 31 gives automatic permitted development rights for the demolition of boundary walls, fences and gates without the need to notify the local planning authority. And subsequently, this element of the proposal is not for consideration today. So the proposal that we're considering today is the demolition of the buildings on the site. So this is a photo that shows the front of the building known as Chrysaide. And that's a side view taken from 4th Chrysaide, which is the name of the road adjacent to it. This photo shows the site from the northeast looking towards the building. And finally, this photo is an area of grassland to the rear of the building. So, let's go back to that. So the Town and Country Planning General Permitted Development Order 1995, Schedule 2, Part 31, Class A, gives permitted development rights for the demolition of buildings subject to the condition that the developer must first submit a notification to the local planning authority to ascertain whether or not the LPA's prior approval is required. This is not the same as a planning application, as the proposal does not need planning permission. The legislation sets out what we are allowed to consider in determining whether prior approval is required, and makes clear that consideration must be limited to the method of demolition and the proposed restoration of the site following demolition. It is not for the local planning authority or this committee to consider the general acceptability of the proposal, the loss of a specific structure or building, or the merits of the proposed demolition. It is also not for us to consider any future redevelopment of the site, as this would be considered under the subsequent planning application for any such redevelopment. Under legislation, the LPA must confirm whether prior approval is or is not needed within 28 days of the receipt of a valid application or notification. There is no scope to extend this time frame, and should the LPA not confirm that their prior approval is required, the applicant would be able to commence the development. So if we don't confirm within 28 days, in essence, they would get automatic consent. If we confirm within 28 days that prior approval is required, we would then have 8 weeks to consider that prior approval. Note that this would still not be a planning application, but rather the second stage of the notification process. So on screen now is a map that has been submitted in support of the application by the developer, which shows part of their method of demolition that they're proposing. So in the case of Chrysaide, which is the notification before us today, NRW have been consulted and have raised no objection in relation to protected species. Originally, Environmental Protection requested further information in respect of the method of demolition, specifically in relation to the noise and dust during the demolition process. The original information also lacked clarity in respect of what material was being proposed for the backfilling of the site in terms of the site restoration. Therefore, in the original report, officers recommended a determination of prior approval to allow for this information to be submitted. However, since the writing of that report prior to this committee, further information has been submitted by the applicant to support the notification. This subsequent information addresses the issues that were raised within the original report. Environmental Protection have been reconsulted and have confirmed that they have no objection to the proposal now. The further information from the applicant also addresses the concerns that were in relation to the site restoration. So within the update report, it confirms that they are now proposing that, well, they've confirmed the material that they're proposing to use with the backfilling of the site, so that is stone. So as a result, you'll have, within the update report, it confirms that office has considered that the notification complies with all the requirements of legislation to be considered as permitted development without the need for prior approval. This recommendation is, however, that the determination be delegated to the chair and vice chair in consultation with the professional lead, Peter Morris, to allow for sufficient time for the site notice to expire. Because of the timeframes with the notification and the 28 days, which we must determine it within, the site notice hasn't quite expired yet. Thank you, Chair.
Thank you, Rhian. Over to members for discussion, please. Councillor Elwyn Vaughan, please.
Diolch, Cadeirydd. Thank you, Chair. Just a couple of points. Obviously, this is a unusual application for us as an authority, and obviously there are slightly different processes in that. However, there's a reference in the documentation to a Cadw visit, which I understood was yesterday. Have we heard anything back from them or any timetable for a response?
Peter, please. Do you want to take it, Rhian?
As it stands today, we have not received any confirmation from Cadw as to whether or not they will be proceeding with that listing. But however mentioned within the presentation, within the scope of the demolition notification, we can only consider the method of demolition and the proposed restoration of the site anyway.
I appreciate that, and I'm well aware where you're coming from in that sense. However, it is obviously a motive issue locally, and there's a lot of feelings about the heritage potentially and history of this building and its sense of place. And I would have thought that a response from Cadw would be quite fairly fundamental as a way forward. I think one of the things initially it was proposed to defer in order to get all the information on board. I would have assumed Cadw would be part of that process, as usually with other applications. But now we have a different approach that they're going for direct approval. I think we should, in essence, have waited for Cadw's response to get a full picture, because there is a strong feeling that things are being rushed through. I know there's a time frame, but for the sake of openness and transparency, I think that would be very beneficial.
Yeah, can I respond?
Yes,
Chair?
yes, certainly.
Yeah, thank you for those questions, Councillor Elwyn Vaughan. In terms of the processes, we've got, I think, as it stands at the moment, the building isn't a listed building. That request has been, my understanding is we have probably members of the public and local interested groups approach Cadw around that, and that's very much a separate process, whether or not it should be listed. I think it is separate, so I'd emphasise that. What we've got in front of us is a notification at the moment around whether the building should or should not be demolished, and whether that should require prior approval or not from us. And we have to restrict our consideration really to the matters that Rhian has put in front of us. And that really is around the scope of the method, and then that follow-up restoration of the site. Are they acceptable or not, or do we require that additional information? And I think the officers strongly of the view that we've had sufficient information there. That's up for discussion. By all means, this committee can discuss whether we've had sufficient information there as to whether or not prior approval should be required. The listing is something that has to sit outside of all of that. And we'll wait and see what Cadw come back and say. They've obviously been approached, but we haven't had a formal response from them. And I'm happy to have that consideration as well. But what we've got in front of us is, we don't do something here, we've got a 28-day clock ticking down, which by default will give that demolition or make that demolition possible if we don't make a decision. Okay.
I fully appreciate that point. My issue is it's too late for CADU listing after it's given the green light to demolition, and that therefore it would make more sense to say that there's a need for full application, and that would give time for the CADU response and enable transparency to be seen to be happening, rather than just being bulldozed through literally. I'll leave it at that for now.
Can I respond to that, Peter?
Yeah, I think if you think prior approval is required, I think you've got to focus in on, have a discussion around those two aspects of what the demolition notice is covering and what we must consider. So if you think further detail is required, that's well within the right of this committee to do that. I think the officer at the moment thinks we've had sufficient detail, so that's available. I don't really want to go into the listing process because I don't want it to influence in any way the decision here on a decision around this. There are separate processes as well we're aware of. I don't think we've had a request. There is a way for listing or a sort of temporary stopgap listing where approach could be made to the authority, and that's got a building preservation notice. I don't think we've had that approach to us either, to my knowledge. So that's an alternative, but that is a separate consideration really to this notification that's in front of us today. Okay.
Okay. Can I ask? Obviously, this is a historic building, and people, when they demolish buildings like this, they take certain ornaments from the exterior of the building. Is there any detail there where, you know, when they're demolishing the building, are they going to try and protect anything, any of the exterior of the building for reuse in other buildings in the area? Is there any detail on that? Salvaging?
I don't believe there is any information in relation to that. The only thing is with that is that would be a consideration of this, whether that comes under more of the historic value of the building, which we can't consider.
No, but obviously we're asking about how the building is going to be demolished. That's the focus I would be going on whether or not any of the exterior that can be reused in other properties. Is that part of the process, or are they just going to smash it all down and cart it away in a skip? Because there doesn't seem to be any detail on that.
Well, within the demolition method statement we've got no confirmation of whether they'll be salvaging anything. They've just concentrated on the requirements set out within the permitted development rights. So there's no requirement for them to state whether they're salvaging or anything like that.
Right, okay. Councillor Howen-Hume, please.
Yes, thank you, Chair. And I pick up on the point you've just made, in so much as many years ago, when the Bear was in Newtown, part of the redevelopment of that site was to incorporate some of the fascia of the Bear. So fully take on board what you've just said there. I just want to pick up on a few things. There is a petition going around in excess of over 500 signatures. Do we take any notice of that or ignore that?
Yeah, I think I've certainly come across that. I think there was an approach to us around an e-petition as well, so it's probably similar to that. I haven't actually seen any petition myself as to what they're actually asking for. I'm assuming it's about saving the building, probably would be my expectation of that. Again, we'll be sort of quite clear here. Our focus and consideration isn't about saving the building. It's whether the demolition of the building is acceptable or not. I could sort of describe it in a different way. If the building was already listed, we could still be sat here with a demolition notice, and we would have to decide whether or not the means of demolition and the restoration were acceptable, it would still require another consent. If it was a listed building, it would require listed building consent. But it wouldn't make any difference really from that determination of the notification, whether or not it's listed. So that's just a different way of looking at it.
Okay, and I did see reference on something yesterday that this was not available on the planning portal. And I've tried it myself this morning and I couldn't find it on the planning portal. Is there a reason for that, please?
Yeah, so as mentioned within the presentation, this isn't a planning application, it is a notification. So planning applications go online, they are published with all the documents for members of the public to view. This is not an application, it's a notification, so it comes under separate processes and procedures with that. Ultimately, it is our opinion, well, it does meet permitted development and the criteria for that. So it is only for us to discuss and debate whether the committee is minded that further information is needed either in relation to the method of demolition or the restoration of the site to make it prior approval or not.
Thank you. And one final question, Chair, if I may. Again, via emails that we've received as a planning committee, we have seen some of the interior features that remain within Crosaudi. That does concern me because they look historic and very attractive and in keeping with the period of the property. I just want to make that comment because I think, there is a lot to lose from within the interior of the property. Thank you, Chair.
Thank you very much, Councillor Howe-Newton. Councillor Gareth E. Jones, please.
Thank you, Chair. Just for my satisfaction, can you just confirm, is the 28 days up next Wednesday? Is that the date that I got in mind?
The 28 days runs out on the 25th of August, so that's a week today.
Oh, thank you. And second question, do we know how long after permission being given the contract would start the demolition, or has that not been indicated?
We do have, if I can find it, we have confirmed. Yeah. I believe it's October that they've indicated, but we'll see if we can find out a definite answer. We look into that and get back to you.
Well, no, if it's around that date, I'm satisfied.
Yeah, I believe it was October that if we granted permitted development, they would be.
Yeah, they could get back together with everything. Yeah. Subject to that, Chair, when you're ready, I'm happy to propose.
That's to go along with officer's recommendation, just to be clear. Councillor Jeff Morgan, please.
Hi, have we a surveyor's report or anything on the state of the building? Or what state of repair is it in now? Do we know that is it in good order, or is it like the roof leaking or?
There is no structural report or anything like that with the application, but from site visits, yeah, it's in good condition.
Okay, thank you.
Councillor Peter James, please.
Thank you, Chair. Under the wildlife situation and the bat surveys they carry out, I mean, has there been enough time to carry that out in the actual element of the application?
The notification was, when it was submitted, it was accompanied by an ecological report. NRW have been consulted on that report and they have no objection. No bats were found during the processing of the report, and NRW are happy with the report results and conclusions.
Thank you.
Thank you. I've got Councillor Gareth E. Jones. Is that a legacy hand there, Councillor Gareth? Okay. I've got a proposal to go along with officer's recommendation. I haven't got a seconder as yet. Thank you very much, Councillor Jeff Morgan. Yeah. Okay, members, those wishing to go along with the officer's recommendation, which is one of a delegated decision with myself, Vice Chair, and the professional lead, Peter Morris, those wishing to go along with that decision, please indicate verbally and now when we come round for a roll call through Carol. Thank you.
So councillor Carl Lewis,
4.
councillor Gareth D Jones,
4.
councillor Tom Colbert,
Abstain.
councillor Deb Edwards, 4. councillor Les George,
Councillor Les. Come back to Councillor Les.
councillor Hylwyn Hume,
4.
councillor Peter James, councillor Gareth E Jones,
4.
councillor Karina Kenyon Wade, councillor Ian McIntosh,
4.
councillor Jeff Morgan, councillor Gwynfor Thomas,
4.
councillor Elwyn Vaughan,
Against.
so councillor Les George,
Councillor Les George. I think we've given him sufficient time to vote, so we're cancelling him out on this occasion. Please go.
so chair, 9 members voted for, 1 against and 2 abstentions.
With officer's recommendation. Thank you very much, Carol. That concludes the planning section today. We're moving on now to, excuse me, item number 5, which is the delegated list. Is there any observations there, members? Or are you happy to approve? Councillor Gareth Jones, E Jones.
Yeah, just it's unfortunate for the officers thing that the first one on the list is one in my ward, and I just noticed how long it's taken to go through the process, and I'm wondering is there any way we can feedback at some stage when it exceeds the normal timeline, because this is like a 9-month period.
Okay. Is it all right that the officer responds to you by email? Is that okay on this occasion? Thank you.
Yeah, I'm not about this specific one. This is in a general comment,
Okay,
because there's 2 or 3 that I've had in my ear that's taken a long time to go through the process.
right.
And I just would like, I think it'd be good information for us to know what is the delaying factor, so we can then go back to the members, the board members making an application, and inform them what, you know, what the process is.
Okay. Peter, do you want to just touch on that?
Yeah, I think rather than maybe do it openly now in recorded session, let's have a discussion around that and how we manage that.
Yeah,
I think there's a training opportunity there, but it's also making sure you as members are kept informed as well and how we best go about doing that. Okay, it's a communication issue ultimately, isn't it? Okay, thank you.
Thank you, Peter. Councillor Edwin Roderick, please.
Thank you, Chair. For those of us on virtual, do we have an option to be able to vote? Because I didn't notice anybody who was being asked on the virtual what their vote would be.
We didn't know that you were in, Councillor Edwin. We hadn't
Oh, sorry.
observed you coming in.
I was just being quiet.
Do apologise there. Just for confirmation, Carol, would Edwin's vote influence the vote in any way, Pete? If he either way, would he, if he was looking at, no, okay.
And you wouldn't have been able to vote if he hadn't heard it.
No, I'm just saying if he was in there, would it have changed it in any way? But it hadn't, it wouldn't have done. Okay, thank you. I'm still looking for any observations. If not, can I have a proposal and seconded to accept the delegated list, please? Councillor Gareth Jones, E Jones, you're happy to accept it? Thank you. Do I have a seconder for that?
Happy to second, Chair.
Thank you very much, Vice Chair. On to item 6 on the agenda, to receive declarations of interest from members relating to the following items. I believe Councillor Tom Colbert, you had an interest that you wanted to come forward with.
Yes, Chair. It was the the proposed village green in Brontlis, which is in my ward.
Sorry, I missed what you said then, councillor Tom.
It's the proposed village green in Brontlis, which is in my ward.
Right, the first one, okay, item number 7. We've got that recorded. Do you want to have a word with him? Is he okay to decide on this application or?
Yes.
Yep, okay, great, okay,
Yeah, no, thanks for that. I'm just not very clear on the process.
thank you very much. Before we move on, councillor Gareth E. Jones, is that a legacy hand? Thank you. Okay. Item number 7. 20001 BG, application to register a new town or village green on land at Brontlis. Method of determining the application. Taking us through this is Sean Barnes. Over to you, Sean.
Thank you, Chair. Please excuse me, I will share the screen briefly. This is an application affecting land at Brontlis. And I think probably the key point about today's report is that it is procedural only. It is not a consideration of the evidence, hence the evidence attached to the case around the case is not attached. I'll just share my screen finally, to show you a picture of the site. Yeah, and I'll expand that slightly, it might be easier to see. So the area of land affected by the application is shown in the red boundary. This plan is an interpretation of the plan that was supplied by the applicant with their application. In producing the interpretation, you do of course go back to the applicant and check with them that it is a true representation, which they've confirmed that it is. Okay, so in terms of the application was made by the Brontlis Green Group, which Mr. Terry Herford is the chair. The application was received by the County Council on the 20th of April 2020, so it was during the COVID pandemic. When we receive an application of this nature, what we are required to do is to check it to make sure that it actually meets basic legal requirements. So accordingly, we met with officers of the legal services team. We had a look through the application and a number of issues needed to be considered. Planning permission for development has been granted on this land. However, that planning permission was granted after the date on which the application for the village green was submitted. Therefore, the planning permission in this case is not regarded as one of the trigger events that removes the right to apply.
Could I just pause you there, Sean?
Yes.
The presentation has disappeared.
Okay, no, I'll switch that off if that's okay.
All right, sorry.
No problem, thank you for checking. No, so it's not regarded as a trigger event that removes the right to apply. So the application does need to be taken forward. However, there was case law that came into effect in December 2019, affecting registration of village greens. And it was concluded that it was necessary to seek an external legal opinion as to whether the application could be accepted. The conclusion was that the application could be processed when we received that advice. Accordingly, on the 14th of April 2021, the statutory form 6 to accept the application as being duly made, meeting legal requirements, was served on the applicant and it was given a reference number, as we are required to do. We're then required to go through an advertising process via site notices and via direct notification of a number of parties. And that did include the applicant, the council's housing services and legal services team, and others, including the community council. And a 6-week period in accordance with regulations was allowed for receipt of objections. An objection was received from the council's housing services and it was within that 6 weeks deadline. The applicant was given opportunity to comment on the objections, which again is a requirement. At this stage, as mentioned earlier, the committee is not being asked to consider the evidence in relation to the application. It is solely about how we determine the case, because there are several options. For a village green application, we can, under some circumstances, consider the documents provided by the applicant and objector, and determine the application solely based on written evidence. And you will see a case like that today. Usually that will be the case where the application is unopposed and there are no complex legal issues to consider. Alternatively, if the case is more complex, and particularly if it's opposed, the council can decide to hold a hearing so that the applicant and objector and the witnesses can appear in person and they can be cross-examined by each other. The committee then determines the case based on the written information and anything else that it hears during that hearing. So it can be a valuable opportunity to gain additional information. So although the council is not required to hold a hearing, it is broadly very helpful because it does allow the applicant opportunity to deal with any matters raised by the objector and anything else that could lead to us rejecting the application. There was also a piece of case law a few years ago, Whitney, which you may or may not have heard of, that in fact it explained that it was defined it was a good idea to hold a hearing where a case is opposed and complex. This application, as you've heard, has been opposed. It does bring into question whether the legal criteria for registration as a village green are met. Therefore, as officers, we have proposed that a hearing would allow witnesses to present evidence in person. It would allow for the applicant and objectors to cross-examine the other parties, and for further clarity to be sought around written evidence. A hearing will be chaired. The hearing can be chaired by the county council, as was the case at Aberystwyth a few years ago. Alternatively, the county council can decide to determine to commission an independent inspector, a legal specialist from outside the county council, who will chair a hearing, who will consider the legal issues, who will write a recommendation based on what they've heard and their knowledge of case law and statute law. The inspector, however, does not determine the case. The law does not allow for that to happen, village green casework. What will happen is they will write a detailed report around what they have heard and their conclusions in the light of the case law and statute law with a recommendation. That recommendation will then come back before this committee. So this committee will still be required to determine the case, but it will be on the basis of a detailed recommendation from an external specialist. This was considered a few years ago after a case at Kai Prior. We looked at procedural issues, and it was considered at that stage that an independent inspector may be appropriate where, for example, a conflict of interest is identified that could be seen to be prejudicial to the council's ability to determine the case impartially. In this case, the council does own the land affected by the application, so a recommendation from an independent inspector would offer that degree of impartiality, albeit that the case will still need to come back to this committee. There are some costs incurred in doing that, and these will be met by service budgets. Chair, before I move to the recommendation, would you like to pause for any questions?
I will indeed. Thank you very much, Sian. Questions from members, please, or are you happy to proceed to Sian's determination? Councillor Tom Colbert, please.
Thank you, Chair. I visited the site some months ago and spoke with residents. Some people are in favour and some people are against. One thing that was mentioned to me was that there is planning, there's been a permission given to build some much needed houses on this site. And there was some concern that having a village green might frustrate that. Can I get some clarification on if that would actually be the case, please?
Certainly, yes, registration as a village green may have an impact. However, that does not remove our responsibility to make an impartial determination for the application, which is key. Colin, I don't know whether from a legal perspective you want to pick up on anything where that's concerned.
Nothing further to add, except to confirm what Sian has just said. We have a legal duty to proceed with determining the application, so we have no choice in that. Yes, as you've heard from Sian, there will be an implication with regard to the housing, but that can't be avoided. We have to proceed with the determination.
Okay, I've got two questions. Councillor Peter James, please.
Thank you, Chair. It's just a question really on expenditure. For if we carried it out through Powers chair to an independent chair that's coming in, what would be the cost difference? Would there be a cost difference to that to Powers?
There would be, yes, in that, you know, there is clearly a budget implication to commissioning an external inspector that, you know, it would be less if the committee were to hear the case. However, what needs to be considered is that these cases can be subject to judicial review, and therefore that needs to be balanced against the upfront cost of seeking an external opinion.
Okay, thank you for that.
Councillor Gareth E. Jones, please.
Thank you, Chair. I just want to know, has been any discussion, just like Councillor Tom, I've visited the site when it's come through, and I know the site from when I worked in school services. Has there been any discussions between the two parties around changing the size of the applicant's site? Because it is quite a big area.
There is reference in the planning documents to green space. However, from the perspective of the Commons Registration Authority, because we have to take a step back and maintain separation of duties, what we have not received is any amendment to the application as made. It is our understanding that the applicant wishes to continue with the application as made, but there is reference to green space in the planning documents.
Thank you.
Thank you. Councillor Tom Colbert, please.
Thank you, Chair. Yeah, I'm of course in favour of green space, but there's the housing is much needed as well. So I understand from Colin that we have to get this determination, we're legally required to do that. But at some stage, I guess people have to decide whether they want housing or they want village green. What form does that play out in, please?
I do apologise, Councillor Colbert. It's a little echoey at this end. Would you mind just repeating the last part of the question? I'm sorry.
Yeah, so at some point, people will need to decide whether they want village green or housing, if there is some conflict there. And I'm not sure what the extent of the conflict is, but where would that be decided? Presumably, someone would have to make that decision. So how is that decided?
The applications are dealt with strictly separately and they must be in law. So the determination of the village green application will go through. There will be an outcome, registration, non-registration, part registration, all the possibilities. What will then need to happen is a consideration of the implications. How does that outcome affect the planning? So it isn't possible to make a decision between the two. It is for the applicant to decide whether they wish to continue with their application or not. And at the moment, our understanding is that they do. We must proceed to determination, whatever that outcome may be. And then we consider the implications on the planning side of things, which in fact, again, will be with colleagues in housing services as opposed to countryside access and recreation team. So I hope that answers the question. They are strictly legally separate and they must be.
Yeah, no, I understand. Thanks very much.
Thank you, members. Back to you, Sian, to take us to your recommendation, please.
Thank you, Chair. The officer recommendation is that application 20001 VG to register a new town or village green on land at Brontleys be referred to an independent inspector. That inspector will then prepare a recommendation and that will come back before this committee for determination.
Thank you, Sian. Councillor Elwyn Vaughan, please.
Thank you, Chair. Just quickly, thank you, Sian, for that comprehensive report. Yes, I think it makes common sense, basically, that we have an impartial person to look at the whole picture and come back with a firm recommendation. So I move the recommendation.
Diolch, Councillor Elwyn. Councillor Ian McIntosh, please.
Thank you, Chair. I was going to say exactly the same thing, but Elwyn beat me to it. I think based on what we've heard this morning, it seems to be the wisest decision, I think, to go to an independent inspector. So I'm happy to second that.
Thank you very much, Councillor Ian. So therefore, members, we have a proposal. We don't have any further questions. So the proposal is that the application 001 VG to be registered as a new town or village green on land at Pronfleece to be referred to an independent inspector. Those members wishing to go along with that, please indicate through the roll call that Carol will be announcing now, please.
Thank you, Chair. So councillor Carl Lewis,
4.
councillor Gareth D Jones,
4.
councillor Tom Colbert,
4.
councillor Deb Edwards, councillor Les George, councillor Hylwyn Hume, councillor Peter James,
4.
councillor Gareth E Jones,
4.
councillor Karina Kenyon Wade, councillor Ian McIntosh,
4.
councillor Jeff Morgan, councillor Edwin Roderick,
4.
councillor Gwynfor Thomas,
4.
councillor Elwyn Vaughan.
4.
So I'll just go back, councillor Les George.
Sorry, Carl, I'm having problems with my computer, right? I'm for the application.
Thank you, councillor Les. So I've gone through all the members, either in the room or on Zoom. There's no one against, nobody abstaining, so the recommendation has been adopted.
Thank you very much, Carol. That is correct. It has been adopted. So we're moving on now to application item number 8 on the agenda. I do apologize. And it is Commons Act 2006, Section 15, application to registration of new town of Village Green on land at Hissington. Taking us through this is Claire. Claire Lewis, over to you, please.
Thank you, Chair. Just bear with me while I work through the technology.
No problem at all.
Okay, thank you, members. So this application is for decision today. So to start with the context, on the 10th of March 2021, the council received an application from Mr. McClintock to register a new village green on land at Hissington. There is no recorded freeholder of the land, but the trustees of the Powys Castle estate hold a qualified title to the mines and minerals in the ground. In accordance with statutory requirements, the application was deemed as duly made and notice of the making of application was published. No responses to the consultation have been received. Given this, it is reasonable to assume that the content of the user witness evidence is unopposed and not being questioned. And so this case is being determined by this committee on the basis of the written evidence only. On screen, you can see the application site, edged and hatched in red. The applicant describes the site as Hissington Village Green and Horsewell. It's 0.03 hectares in size and a irregular shape as identified on the plan. The site is bounded to the west by the county road C2056 and to the north by an access road and public footpath. The eastern boundary of the site is a combination of a low stone wall and heavy foliage. You will see on screen a photo of the site. The site comprises the village notice board, a public telephone box, a public bench and the horse well. This is sort of from the back of the site, looking towards the chapel opposite. And then we've just got sort of more detailed pictures of either side there as well. The statutory requirements are contained in section 15.2 of the Commons Act 2006. This enables any person to apply to the Commons Registration Authority to register land as town or village green, where it can be shown that a significant number of the inhabitants of any locality or of any neighbourhood within a locality have indulged as a right in lawful sports and pastimes on the land for a period of at least 20 years. and they continue to do so at the time of the application. The determination requires the straightforward application of law to the facts. Any other issues, including those of desirability or community needs, are not legally relevant. The burden of proving that the land has become a town or village green lies with the applicant. The standard of proof is the civil standard, that is the balance of probabilities. So we'll now move to the legal tests in turn. Firstly, whether use has been by inhabitants of a particular locality or of any neighbourhood within a locality. Locality has a specific legal meaning. It cannot just be any area of land which an applicant chooses to mark on a plan. It must be an area of land known to and recognised by the courts, such as a borough, parish, or other local government unit or manor. An ecclesiastical parish can be a locality. A neighbourhood need not be recognised as an administrative unit. A housing estate, for an example, can be a neighbourhood, but it cannot be any arbitrary area drawn on the map. There must be a degree of cohesiveness. A neighbourhood does not have to be within a single locality. The applicant has put forward, and the application is based on long use of the application land by the inhabitants of the area marked on Plan B, which is found at Appendix 2 in the documents. The applicant has chosen to identify the administrative area of Hissington electoral ward as the locality. The addresses of all the persons who have submitted a supporting statement have been checked, and apart from 2, it appears that they all reside within the Hissington ward. It is noted that the dates of use of the application site by those same 2 people are outside the 20-year qualifying period. The current residence of one user witness is uncertain, but the home referred to in this statement is within the Hissington electoral ward. So we move on to whether use has taken place over a period of 20 years. Section 15.2 makes it plain that the 20-year period is the 20 years ending immediately before the application is made. Use must be continuous in the sense that it has not been interrupted for any significant period of time. However, any periods of statutory closure can be disregarded. In this case, the application was submitted in 2021, and therefore the relevant 20-year period is 2001 to 2021. From the user evidence submitted, it appears that the land has been in use throughout the relevant period of 20 years and indeed continues to be used. It is of no relevance that some statements support use over a much longer period. And I should add that all the statements are in the accompanying documents that you've received. So we move on to whether the use of the land has been for purposes of lawful sports and pastimes. Lawful sports and pastimes include informal recreational activities, such as walking with dogs and children playing. It does not include walking of such a character as would give rise to a presumption of a right of way. There is no need to show that every square inch of the land has been used. In this case, the evidence supplies that application land has been used for a range of recreational activities, such as children playing, picnicking, community get-togethers, and carol singing. Another key test is whether the use of land has been of right. The phrase "as of right" has a particular legal meaning and simply means that the use must be made openly, without force, without secrecy, and without permission. User is by force if access has been obtained by climbing over fences or gates or by ignoring notices that prohibit entry. Permission can be expressed orally or in writing or by notices which permit a temporary right to use of the land. In this case, there is no suggestion that the use of the application land by local residents took place in secrecy or by force or were given formal permission to use it. If we look at whether the land has been used by a significant number of inhabitants of the locality, significant does not have to mean considerable or substantial. What matters is that the number of people using the land in question has to be significant to indicate that their use of the land signifies that it was in general use by the community for informal recreation, rather than occasional use by individuals as trespassers. The population of the Hissington electoral ward is estimated to be in the region of 250 to 300 people. The application is supported by user evidence statements from 18 residents, only 15 of whom lived in the locality at the time of the application or at some point during the qualifying 20-year period. The evidence from respondents from outside the locality does not therefore carry as much weight as that of inhabitants of the locality. The evidence supporting this application, in particular the number of witness statements made by local residents regarding their recreational use of the land and the use of others, therefore satisfies this test. So the options open to the committee. If the committee is satisfied that the application meets all of the statutory requirements, then the committee should accept the application, and acceptance means the land will be registered. Or if the application fails to satisfy one or more of the statutory requirements, then the committee must reject the application, and rejection means that no registration may take place. I'm now going to hand over to the chair for any comments or questions on the application.
Thank you, Claire. Over to members for discussion, please. Your hands, members. No? Okay. Back to you, Claire, to take us to your recommendation, please. Oh, hang on, Councillor Howland. No, that's okay. Okay. Over to you, Claire, to take us to your recommendation. Okay.
Thank you, Chair. The recommendation that the application to register the parcel of land at Hissington, as shown on Notice Plan 21001 VG, be accepted and that the land be formally registered as a village green.
Okay, over to you, members. Councillor Howland here, please.
Yes, thank you, Chair. Claire, thank you very much for the presentation today. It's been very informative and very useful for us to back up what has been reported in the documentation as well. So based on that, I propose we take your recommendation. Thank you.
Thank you very much, Councillor Howland. Councillor Jeff Morgan, please.
Yeah, I'd like just to second that.
Thank you very much, Councillor Jeff Morgan. There are no other speakers on this application, so I'll put it to the vote. Those members wishing to go along with the officer's recommendation that an application be registered of land at Hissington as shown on the notice 21-001 VG be accepted and that the land be formally registered as a village green. Those members wishing to go along with that, please indicate in the roll call that will take place now. Thank you.
Thank you, Chair. Councillor Carl Lewis.
4.
Councillor Gareth D. Jones.
4.
Councillor Tom Colbert.
4.
Councillor Deb Edwards. Councillor Les George.
4.
Councillor Hywel Hume. Councillor Peter James.
4.
Councillor Gareth E. Jones.
4.
Councillor Karina Kenyon Wade.
4.
Councillor Ian McIntosh.
4.
Councillor Jeff Morgan.
4.
Councillor Edwin Roderick.
4.
Councillor Gwynfor Thomas.
Councillor Gwynfor.
No.
No. Okay.
Councillor Elwyn Vaughan.
4.
So Councillor Gwynfor Thomas.
Looks like you might have dropped out.
Yeah, okay. So 13 members have voted for, Chair.
That meets with the officer's recommendation. Thank you very much, members. It brings me now to a very sad part of this meeting. We're having to say goodbye to Colin Edwards here. Just like to thank you, Colin, for all your legal advice, keeping this committee legal since I've been here since 2017. How many years have you been in the council now?
37, Chair.
37.
Not quite.
Not quite.
Few days to go, I think.
Not quite. Well, on behalf of the committee, I wish you a very happy retirement. And we never know, you might see you back here doing some subbing work, or you might take up a post a bit like Councillor Gareth E. Jones and come back as a councillor.
Well, it looks far too difficult from where I'm sitting. Chair.
Well, thank you very much anyway, Colin.
Thank you very much for your time.
Okay, members, leaves me to ask Carol for the date of our next meeting, please, if we got one. If we haven't, no problem, it'll be emailed out.
Yep, Chair, the next meeting is on the 8th of September.
8th of September, everyone. Okay, brilliant. Thank you, members. Thank you, officers who are presented today. Thank you, members who are at home and the public that are going to be watching this recording, and members of the press. I close this meeting. Thank you very much.
Thank you, Chair.
Right, diolch yn fawr.
Chair, thank you, man.
Hwyl fawr i pawb.